Hi, welcome to Pamela Price Unfiltered. I'm Pamela Price, your host, and this is a space and a place for real talk. This podcast is all about raw, unfiltered conversations on politics, law, education, culture, systemic racism, and everyday events shaping our world. We'll go beyond the headlines to dive deep into how some of our most pressing issues are impacting real people, real families, and our communities. My goal is to help you navigate the complexities of today's world. We'll hear from community leaders, activists, lawyers, educators, healers, and everyday people on the front lines of change. Each episode will tackle an issue, breaking it down in a way that's honest, informative, and actionable. For those tuning in for the first time, I'm Pamela Price, a longtime attorney, political activist, and champion for justice. Please subscribe to my YouTube channel to watch the show and to my Substack to read the weekly word. Your support keeps the conversation raw and unfiltered. And you can listen to this podcast wherever you get your podcasts. Welcome to the show. Let's talk about it. Today's guest on Pamela Price Unfiltered is the Honorable Chesa Boudin. Chesa Boudin is the founding executive director of Berkeley's Criminal Law and Justice Center, a policy and advocacy hub. Chesa served as San Francisco's elected district attorney from 2020 to 2022. During that time, Chesa implemented reforms to ensure that the criminal justice system delivered safety and justice for all. He significantly expanded the office's Victim Services Division, eliminated prosecutors' use of money bail, prosecuted police for excessive force, sued the manufacturers of ghost guns, expanded diversion to address root causes of crime, and reduced incarceration significantly. Under Chesa Boudin's leadership as a San Francisco DA, both violent and nonviolent crimes fell by double digits in San Francisco. Prior to his election, Chesa clerked for 2 federal judges and worked for years as a deputy public defender. Chesa is a graduate of Yale College, my alma mater, and Yale Law School, and attended Oxford on a Rhodes Scholar. His biological parents spent a combined 62 years in prison, starting from when he was a baby. It's my honor to welcome you, Chesa, to Pamela Price Unfiltered. Thank you for joining me.
Thank you. It's a pleasure to be with you. I enjoy listening to your show, and now it's an honor to be on it.
Oh, thank you. So we have a lot to talk about. I first want to talk about one of the recent articles that I thought was so appropriate for both you and I was an op-ed piece by David Greenwald of the Davis Vanguard publication. And David talked about the double standard for reform prosecutors and for tough on crime prosecutors, and cited a number of examples where the tough on crime prosecutors seem to get a pass both in the media and the courts, and usually by the state bar, versus how progressive prosecutors or those committed to reforming a broken system are often placed under intense scrutiny, as you and I were. Can you speak to what are your thoughts about this double standard?
Well, first of all, it's important to recognize that the double standard exists, and it's clear as day if you start looking. And it exists at every level of analysis, of scrutiny, of media coverage, of criminal justice reform and reformers. I'll give you a couple of classic examples, but when you or I were in office and somebody who had a prior case was released on bail or after a plea deal, if they were rearrested, the media, the social media universe would blame us personally, as though we had gone in there and pulled strings to get this dangerous person back on the streets. Never mind the role the judge played, or what the strengths of the case against them had been, or what mitigation might have been presented. But you simply do not see that level of criticism connected with the elected DA in traditional prosecution jurisdictions. And I could give you literally hundreds, thousands of cases where you or I or other reform prosecutors have been personally attacked and blamed directly and indirectly by the media, by commentators, by victims' rights advocates. And you look at exactly the same kinds of situations, and nobody's talking about the district attorney when they're a more traditional prosecutor. I'll give you another higher level example of this same double standard that's really bothersome, because it undermines the ability both of the electorate to choose their representatives, feeds into recalls and other similar tactics, but also it undermines the ability of elected officials to implement good public policy. So when I was district attorney in San Francisco, as you mentioned in the introduction, crime was falling. It was at or near record lows. And nevertheless, you had pundits across the planet, some of the really conservative British press, the New York Post, US senators going on Twitter, people with huge platforms blaming me personally and criminal justice reform more broadly for whatever violent crime did occur and get reported in the news. Meanwhile, you have Republican-controlled jurisdictions in places that are similar in size to San Francisco. Let's say, for example, Kern County, California, where you have very traditional, tough on crime, conservative Republican prosecutors, and you have violent crime and homicide rates that are much higher than anything we experienced during my tenure. And yet nobody's talking about how their policies are failing. Nobody is blaming their punitive, draconian approach for violent crime. So there is a double standard, and it's one that is deeply rooted, widespread. It's not limited to Republicans or Fox News. This is something we see even in mainstream liberal media, and it really undermines evidence-based practices and the kinds of policies that voters across the country are making clear they support.
Right. Exactly. Yeah. I always say, or my catchphrase is that politics is trumping public safety, because what we see undermines public safety when you don't hold these traditional prosecutors accountable in the same way that you or I would be held accountable. You also mentioned one of the ways where there's a double standard where we would see it reflected nationally was with respect to Trump's pardon, his decision to pardon people. We were attacked for trying to implement the resentencing laws in the state of California that are on the books for a reason, good public policy, definitely about public safety, and yet on the flip side, you have Donald Trump pardoning people who clearly were a danger to public safety and clearly were trying to overthrow the government. And yet that seems to be okay. Nobody's
Yeah,
concerned about that.
there's just a lot more political space for conservatives to do things. Another example, pardons, clemencies. I mean, there's just no question Republicans feel much more emboldened to pardon people, whether it's political cronies and corrupt white collar folks, or whether it's people involved in violent crime than Democrats do. And I think you see the same thing play out at the local level with a plea deal. If you're a conservative traditional DA, you announce a plea deal and people say justice was served. The defendant pled guilty and there's going to be consequences. When you and I and other reformers were in office and we secured plea deals, not only did we get it often from the left, for people saying you're doing the traditional thing, but we would get it from the right who said, why didn't you take this case to trial? And of course, the irony is anybody who is serious about criminal justice policy understands most cases, about 98% of criminal cases, don't go to trial in our system. It's not possible for every case to go to trial. And yet when I was DA, a lot of the advocates were saying every single domestic violence case that you file should go to trial, no plea deals. They were saying the same thing about DUI cases. They were saying the same thing about murder cases. And at a certain point, it's like, well, they don't say that to they didn't say that to Nancy O'Malley. They didn't blame her when a murder case got resolved with a plea deal. So there is a very real double standard. It plays out at every level of the system. One last example I give you, in San Francisco, when people would get released pre-trial, and I was in office, they would blame me. It was because I supported bail reform or because I wasn't tough enough. As soon as I got out of office and they replaced me with the mayor's handpicked, so-called tough on crime prosecutor, well, guess what? Some people were still getting out of custody pre-trial because that's what the law and the Constitution require. And all of a sudden, they're not blaming the DA. Now they're blaming the judges, and they're trying to challenge judges and run people against the judges. They need a scapegoat, but it's not going to be the traditional conservative DAs.
Right, right. Never them. Right, exactly. The hubbub about plea bargains, you're absolutely right. Plea deals happen every day, all day. And it's very obvious to me for my current successor under the new DA, nobody's following any plea deals that she's doing. It's all anonymous and it's justice. They've closed up the black box of justice that we tried to open up so people could see. And justified that as if, well, everything's fine now.
Look, fundamentally, it comes down to benefit of the doubt, and when you're trying to change a broken system, as an outsider, the way you and I were, they don't give us the benefit of the doubt. And when you're an insider doing business as usual, kicking the can down the road, even when everybody knows the system is failing us and is making us less safe, people look the other way and they just assume what you're doing is normal and appropriate, even if you're engaged in corruption, unethical behavior, covering up racial bias in death penalty cases, you name it.
Right, right. The other thing that is different that you and I talked about in a panel you hosted a couple years ago was about prosecutorial discretion. I became more and more convinced that as long as Nancy O'Malley was the DA, she had prosecutorial discretion. The moment I became the DA, there was no such thing as prosecutorial discretion, and my judgment could not be trusted. I had no discretion. Everybody had a question about whether or not I actually knew what I was doing. And the kind of discretion that prosecutors actually need to make decisions was something that people just essentially felt like I was not entitled to. Can you speak to the importance of prosecutorial discretion and how that has operated in our system?
It's really a good example of what we were talking about earlier with double standards, because you take a traditional prosecutor, nobody would say to you they should have no discretion. I mean, but you get a reformer and all of a sudden the right-wing pundits are saying, no, they should charge every crime. It's on the books. The police make an arrest. The prosecutor should charge. That's not how the law works. That's not how resource allocation works. Prosecutors and the justice system in general do have limited resources. They may be overfunded in certain ways, but they have limited resources. And it is a quintessential defining part of the job of an elected prosecutor to make difficult decisions about what kinds of crimes to prioritize and what kinds of accountability to prioritize. And sometimes that means, as it did for me and for many reform prosecutors, that we're going to put more resources into serious and violent crimes than we are into so-called quality of life crimes. That is the kind of decision that is in the heartland of what elected prosecutors do and why we choose to elect prosecutors. Look, fundamentally, if there were no discretion in the job, you wouldn't need to elect them. It would just be a bureaucratic administrative role. But it's a classic example of where when you are elected and you are using your discretion the way you promised voters you would. I told voters very transparently, as you did during my campaign, what I would prioritize and what I would deprioritize. And when you start doing exactly what you promised and what voters elected you to do, the criticisms are loud and constant. A chorus of people saying, wait a second, you're not enforcing the law, you're not prosecuting. And when traditional DAs prioritize shoplifting or trespassing over murder, you just don't hear people criticizing them or second guessing those decisions or trying to undermine prosecutorial discretion in that way. And lest listeners think this is just about me and you, this is happening across the country. I mean, in Florida, for example, Andrew Warren, who was elected, a career prosecutor, was elected and believed in certain, modest, data-driven, evidence-based reforms, signed a letter saying he would, in his discretion, choose not to prioritize enforcing crimes in the state of Florida that criminalized abortion or reproductive health care. And as a result of that decision, a public, transparent decision well within his discretion as an elected official, an elected prosecutor, the governor of the state summarily removed him from office, right? This is happening across the board. You simply don't see the opposite, or the parallel happen with traditional prosecutors who say, I'm not going to go after police violence. Nobody says to them, wait a second, that's not within your discretion. You must file cases every time a police officer shoots and kills an unarmed person. So it's a real frustration and a real challenge to reform.
Absolutely. It's a challenge to public safety because people are playing politics with people's lives.
That's right.
And when you're trying to reform the system, you try to make it better, make it fairer, make it really serve the interest of your community. For example, my priority was gun violence. This is the thing that I believe is the greatest public threat to public safety in Alameda County. And yet, the governor of California had a different priority. And so therefore, because his priority was different than mine, people thought, well, you must be doing something wrong. Well, no, I'm doing the job that people elected me to do. And the governor needed to do his job from my perspective.
Well, look, let me just make one last point on this, because it's the notion that there's no discretion or should be no discretion in prosecution is just so patently and obviously false. I mean, just look for a moment at the way the sentencing provisions work in the state of California. Every felony has 3 possible sentences, right? And that is actually more complicated even still, because you have probation, but there's the low, the mid, and the high term. And it is up to prosecutors to make a recommendation to the court about which of those sentences to impose. That's an act of discretion. And by the same token, there are many crimes, whether it be assault, whether it be theft, whether it be burglary, that under the law can be either misdemeanors or felonies. And it is a required part of the job of prosecutors to exercise discretion based on the facts and the circumstances to decide which of those categories, if any, to charge. So to say we shouldn't be exercising discretion is absurd. It's pure politics.
Yeah, pure politics, pure politics. Let's talk about the politics of the national. The Supreme Court last Friday, June 27th, issued what I believe to be a monumental decision on the power of the federal courts to restrain Donald Trump. And they basically said the courts are now sidelined and Donald Trump can rewrite the Constitution with the stroke of a pen and the court can do nothing about it. Tell me from your perspective, you're now at Berkeley. It's a policy advocacy hub. I'm sure you folks are having some conversations about that. Can you share with my listeners what the concerns are in this moment?
Well, there are so many concerns. And, this is another example at a national level of how these double standards play out. I mean, we've been talking about it in the context of individual, district attorneys, your tenure, my tenure. But I want to just remind listeners of the approach that these same conservative national legal forces took back in, the Obama era, when the Affordable Care Act passed, and these conservatives were desperate to prevent it, desperate to prevent poor people from getting health care, desperate to prevent the first Black president from achieving his signature legislative package. And so they launched a full frontal litigation campaign against all different kinds of aspects of the Affordable Care Act, so-called Obamacare. And to do so, they engaged in what litigators call forum shopping, where they tried to file cases strategically in jurisdictions where they thought they could get the most sympathetic judges. And they found some places, I think in Texas or Louisiana, where they had some extremely conservative judges, district court judges, trial level judges, and they got those individual judges based on spurious, false legal arguments to grant nationwide injunctions that significantly delayed the implementation of Obamacare. Now, at the time, conservatives were cheering the power of the judiciary to slow down this national agenda. Here we are, the shoe's on the other foot, and when you have a judge issue a nationwide injunction about something as fundamental and ingrained in the bedrock of our culture, of our national identity as birthright citizenship. I mean, we're not talking about some random, new legislative issue. We're talking about something that is a defining feature of who we are as Americans, as what our country has represented to the world, as what the Statue of Liberty, has stood for all these decades and centuries. And they're saying, no, 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 we can't have an individual judge, weigh in on that. This is only something for the Supreme Court, or in limited circumstances, for individual judges to have the power to do. And it is a very dangerous sign for democracy, for the rule of law. And also, it's a reminder of the fact that so many of the procedural arguments that you see these conservative folks make are absolutely and purely unprincipled strategic politics. They
Right.
don't care. They don't have principles when it comes to the procedures. They don't have principles when it comes to the rules of the game. It is about power. And they will
Right.
do what they can to take and hold on to power. We saw that with the January 6th, with the fact that they were able to kill a law enforcement official and get full pardons. Imagine if you had exonerated someone who killed a law enforcement officer. I mean, but Trump comes in, he does it, and law enforcement is quiet. So the double standards, the procedural arguments, the moral high ground is just pure politics.
Yeah, yeah. And that's what we see in this country today is so much of public safety and our basic constitutional rights are subject to really right-wing politics coming out of, the Federalist Society, the Heritage Foundation. And you're right, it's very strategic. They have been strategic for decades now, working to undermine the basic civil rights that people believe we have, that in fact are on paper, but they can't be enforced. At least under this new Supreme Court decision, a federal judge cannot enforce the law against King Trump. Now that's pretty crazy, right? What would you say about the death penalty? Let's talk about that. I was very honored to have you participate with our office in resolving and addressing some of the systemic inequities that we found in Alameda County, using discriminating against Jewish people and Black people in death penalty juries, and most likely other juries, serious crimes, where the same deputies who were violating people's constitutional rights in death penalty cases were still trying other cases, right? And training other lawyers about how to discriminate against residents in my county of Alameda. So can you speak to the work that your center was providing and doing with respect to death penalty cases in Alameda County?
Yeah, I mean, first of all, I'll say that I am morally opposed to the death penalty for lots of reasons. I don't think that the state has the legitimate role of taking life. I don't think we can tell other people not to kill when the state, on behalf of all of us, is killing.
Right.
And I was proud that when I was district attorney in San Francisco, we were able to get the last person on death row in California out of San Francisco County off of death row through a resentencing initiative. The work that we did in partnership with your office mainly focused on LWOP cases, not death penalty cases. But I followed very closely as your office took on the really courageous work of exposing a shameful history in Alameda County of racism, of sexism, of discrimination in the death penalty jury selection process. And I want to be really clear, even if you support the death penalty, even if you believe that in some egregious, extreme cases of violence, the death penalty is a appropriate punishment to consider. Nevertheless, you have to also agree that due process, that that the rule of law, that a fair trial is essential before the state can consider imposing the death penalty, right? I mean, nobody would say we should execute innocent people. Nobody would say we should execute people whose conviction or sentence was secured through trickery or violation of constitutional rights. And yet, what your office found in these old boxes, in these old case files, in these old jury selection notes, was, I mean, you wouldn't believe it if somebody told it to you. You had to actually see the handwritten notes on the jury selection case files where people were saying horrific things, sexualizing Black women, talking about Jewish people as being too friendly with African American people, and on and on and on, and making decisions about who would serve on a death jury based on what are clearly impermissible categories and bases. So to do that work, which you did, and I was proud to see you do from my vantage point at Berkeley, only now to look at your successor and see her turn around and defend these sentences. I mean, again, it's one thing for her to say, I support the death penalty in appropriate cases. But it is quite another thing for her or anybody else to defend a death sentence that was secured in the unconstitutional, immoral, unethical manner that so many of those Alameda sentences were secured. It's shameful.
Right. Absolutely. And to say that you are a prosecutor who has, as an officer of the court, and you've taken an oath to do justice, it's outrageous. And, you know, the dark secret of Alameda County's exclusionary practices was hiding in plain sight since 2005. But it wasn't until we saw the notes, the actual notes that were found by Amy Solway, that there's the proof. And you can't dispute the proof. And so you're right. They're not disputing that the convictions were obtained in violation of the Constitution. What they're saying is that there's no remedy for that. And that is certainly against the law and should not be condoned at any level by the court, by the DA, at any level. And, you know, certainly we followed the mandate of Judge Chambria. We were aware that all across the Bay, other counties were, in fact, doing their part to remove people from death row. Santa Clara County, Jeff Rosen, took immediate steps to remove all death penalty convictions. And so Alameda County was the outlier when we discovered this, and we quickly worked to try to bring it into line with other counties.
Yeah, and let me just say, it's disingenuous to say we're aware of these serious constitutional violations, but there's no remedy. And as a result, someone's going to be killed. I mean, how can you call that justice? How can you say that you're acting in the interest of justice? I understand that sometimes it takes being a smart lawyer to figure out what the remedy might be, but we are more than capable in this day and age, in California, we are more than capable of coming up with remedies when there are constitutional violations. It's what lawyers do every day. It's not that complicated. And the notion that you would allow and be complicit in the execution, the taking of a human life, when you know and admit and acknowledge and cannot possibly deny the illegal mechanism in which that death sentence was secured, it's a disgrace. And it undermines the rule of law, and it decreases the legitimacy of all of the other punishments that are being handed out by the office that takes that position.
Right, right. It makes the office just makes it clear the office does not respect the law, and that's unfortunate. So tell my viewers, what has life been for you after the recall? I'm sure people want to know.
Well, I'll tell you what, the recall was hard. It was hard in ways that certainly you appreciate, having been through one. It was hard also for me because during the time that I was being recalled, my father came home from prison after 40 years. My uncle became very ill, and I became his court-appointed guardian. And my mother died after a 7-year battle with cancer. So we were dealing with a lot on the home front. My new son, my first son, was born just 9 months before the recall election day itself. And so I was also during the entire recall period dealing with learning to be a father and parent. It was on all sides. So for me personally, my life is a lot better after the recall. You know, I'm horrified by what I see in local and national politics, by the changes in policy around public safety here in the Bay Area. And it is distressing to watch the ways in which real progress is being rolled back and undermined in favor of failed policies that we know don't work. It's distressing to see the double standard that's being applied in the process of those rollbacks. But for me personally, I have a lot more time with my family, and I get to do deeper, longer term work through my job at Berkeley Law School than would be possible in elected office because of the nature of election cycles, 24-hour news, feels like 24-second news cycles these days. And so I really enjoy working with students. I like the deep thinking. I like the fact that the people I'm surrounded by at the University of California are much deeper thinkers, much more integrity and honesty than so many of the politicians that I had to work with when I was in office.
I feel you. I hear you. And I'm honored by your experience because I want to say that, and I say this often to people, what doesn't kill you makes you stronger. And so to hear that you battled all of that, that you were in the vortex of all of that, and yet you have emerged and are still a force to be reckoned with. That's inspirational, I'm sure, for your students, and it should be inspirational for my audience. So,
Thank you. That means a lot. That means a
yeah,
lot.
of course.
One of the examples of things that I get to do now that I really didn't have time to do, especially in the final months of the recall, is I get to take my son to his swim lesson, and that's what I'm going to do tonight. During the recall, I would often leave before he was awake, and I would come home after he was asleep, and I really missed out on a critical period of his early first year, and it's been great to make up for that lost time and get to do things like take him to swim lessons. So that's what I'm going to be doing tonight.
Yeah, and I appreciate that. I think people underestimate the sacrifices that we made for our community, the intensity of the work that we did from, morning to night. I know I work 12-hour days almost every day, and how draining that can be. But how passionate and committed that we were to our community. And that's what it takes to be able to do that work and withstand, all of the challenges that come with it. But it's good to have a post life. I'll say that.
Indeed. Cheers to
All
that.
right. Yes. All right, Chesa. Thank you so much for joining me on Pamela Price Unfiltered. You take care.
You too. Thank you for having me. Bye-bye.
Okay. Bye-bye.
Welcome to Legally Speaking. On Friday, June 27th, the United States Supreme Court issued its decision in Trump versus Casa. The case is known in the media as the birthright case. It's actually 3 cases combined before the Supreme Court from 3 different courts. The plaintiffs who filed the cases include 22 states, the city of San Francisco, the District of Columbia, many individuals, including pregnant women, and 2 nonprofit organizations representing about 680,000 individuals whose children could be denied citizenship if Trump's executive order goes into effect. The plaintiffs asked the district court to stop Trump's executive order 14160, which essentially rewrote the Constitution on the first day of his second term to eliminate birthright citizenship for millions of Americans and their descendants. We've talked about the executive order in previous episodes and how almost every court that has heard the case has ruled that the order is unconstitutional. The Supreme Court did not say whether or not the executive order is unconstitutional. Trump went to the Supreme Court on a procedural issue with real-life consequences. The question was whether a district court judge has the power to stop or enjoin an unconstitutional order when his or her decision will impact the whole country, or if the only people who can benefit from the court's decision are the actual plaintiffs to the case. Before Trump became president, that was not a real question. The Supreme Court allowed universal injunctions to be used to stop the implementation of Obamacare and numerous initiatives by President Biden. Trump's court ruled that because universal injunctions were not used by English courts in the colonial era, by the founding fathers going back to 1789, federal courts now lack the authority to issue them. By creating a rigid historical test for what type of relief is available, the Supreme Court essentially froze in amber the precise remedies available in 1789. The last time this happened with devastating impact for the country was the Dred Scott decision in 1857, which essentially froze Black people in a state of permanent inferiority and enslavement. The court left open as a remedy to protect our collective constitutional rights the ability to file a class action. How many times in my 30 years as a civil rights lawyer did people come to me and say, I want to file a class action? Class actions are incredibly expensive, difficult, long, and drawn out. The last class action I worked on took 13 years, and we never got the class certified. I filed it in 2003, but the judge would not let us even file the motion for class certification until 2008. When he retired in 2009, the case was reassigned to another judge, and the new judge ordered us to refile the motion a year later. When the Supreme Court decided the Dukes versus Walmart case in 2011, they changed the rules for class certification, and the judge ordered us to refile our motion a third time in 2011. The court eventually denied our motion for class certification in 2012, almost 10 years after we started. A class action needs at least 100 people, thousands of dollars to pay for depositions and documents, and a lawyer who can afford to take a case on contingency that they might not ever get paid or get paid many, many years later. That makes the class action remedy virtually unattainable for most people. The Supreme Court also suggested that the government can create a two-tiered system where a child's citizenship status would depend on what state they were born in. Some children would receive Social Security numbers, some would not. Unless their parents have the financial means to sue the government or can successfully challenge the citizenship order in removal proceedings, children without Social Security numbers will be denied public services. This will create chaos. And in that chaos created by Executive Order 14160, coupled with Trump's quota for deporting 3,000 people a day, we should not be surprised to see ICE and Homeland Security agents stalking women at hospitals across the country, looking for babies to seize and deport to meet their quotas. Aside from the chaos, the court seemed willing to accept. The bigger question was who can stop King Trump? Justice Ketanji Brown Jackson pointed out that the court endorsed a new, quote, zone of lawlessness, which will disproportionately impact poor people, uneducated people, unpopular people, anyone who can either not find or afford a lawyer to file a lawsuit will be subject to the unconstitutional whims of King Trump. Justice Sonia Sotomayor wrote the main dissent in the Trump versus Casa case, and she pointed out that, quote, by stripping all federal courts, including itself, of the power to grant universal relief, the court kneecaps the judiciary's authority to stop the executive from enforcing even the most unconstitutional policies. Justice Sotomayor concluded that the court's decision is nothing less than an open invitation for the government to bypass the Constitution. Until the day that every affected person manages to become a party to a lawsuit and secures for himself injunctive relief, the government may act lawlessly indefinitely. A sad day in America is how Justice Ketanji Brown Jackson describes it. It was the day the United States Supreme Court issued its decision in Trump versus Casa. This decision will probably be one of the most significant Supreme Court decisions in American history, along with the Dred Scott decision and Brown versus Board of Education. This is the day in history when the United States Supreme Court crowned Donald Trump the King of America, or in Justice Jackson's words, quote, endorsed the creation of a zone of lawlessness within which The executive has the prerogative to take or leave the law as it wishes. On Friday, June 27, 2025, the United States Supreme Court ruled that Donald Trump can rewrite the Constitution with the stroke of his pen, and there is no court in the land that has the power to stop him, not even the United States Supreme Court. Clarence Thomas first floated this idea of hamstringing federal district court judges 8 years ago in Trump versus Hawaii. One might ask, is this all on him? Ironically, Justice Thomas was nominated to replace Thurgood Marshall, one of our nation's greatest civil rights lawyers, while Amy Coney Barrett was nominated to replace Ruth Bader Ginsburg, a champion of civil liberties on the court. Justice Barrett clerked for Justice Anton Scalia in her younger days. Trump first appointed her to the bench on the Court of Appeals in 2017 in his first term. He came back and picked her less than 3 years later for the United States Supreme Court in 2020, when Ruth Bader Ginsburg sadly passed away before the end of his first term. Justice Barrett is the justice that Republicans rammed through the Senate at the last days of Trump's first term, after they refused to consider President Obama's Supreme Court nominee in the whole last year of his term, with some fake excuse about allowing the American people to have input in his selection by voting. Barrett was confirmed 8 days before the 2020 presidential election, which Trump lost. Senate Minority Leader Chuck Schumer, a senator since 1999, called Barrett's confirmation, quote, the most illegitimate process I have ever witnessed in the Senate. Barrett has been involved with the Conservative Federalist Society, the American Law Institute, and the Notre Dame anti-abortion group Faculty for Life. So we know that she is a pro-life, pro-gun, anti-immigrant activist and a staunch supporter of Donald Trump. She has described her judicial philosophy as originalism. She believes that the Constitution has a fixed original meaning that cannot be and has not been changed since it was ratified in 1787. In 1787, however, Black people weren't even fully considered human, Indigenous people weren't American citizens, and women weren't full citizens. Originalism was the basis of the Dred Scott decision in 1857, where the court ruled that Blacks were considered so far inferior that they had no rights which the white man was bound to respect. Barrett is a modern-day version of Phyllis Schlafly or Rebecca Latimer Felton. She is a white woman who is clearly invested in protecting and upholding white male patriarchy. So it's not surprising that Barrett would take the unusual step of demeaning a fellow justice, the only Black woman on the Supreme Court, Justice Ketanji Brown Jackson.
And I just want to point something out that I don't know if folks have picked up on this or even know about this, but Justice Barrett gets personal going after Justice Jackson's dissent. And I want to let me read you this from this story, or from her dissent. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself, wrote Barrett. We observe only this: Justice Jackson decries an imperial executive while embracing an imperial judiciary. All right, Mark, look, this seems to me, when I read this, it seems to me that the comity that we have long known about the Supreme Court is gone. Like, the gloves are off when they're getting this seems to be a very personal response from one justice to another. Or am I reading too much into it?
It's very personal, and I think it's extraordinarily disrespectful and inappropriate from Justice Barrett, who touts herself as being collegial and professorial, but in this case clearly felt wounded by Justice Jackson's critiques. I think Jackson's blows clearly landed here. And Barrett responded with what I do agree is a far too personal retort that accuses Justice Jackson of not really being smart enough, I think, to levy a strong criticism of her opinion. That's totally out of bounds. It's highly unusual. Even when the justices disagree, they usually do so respectfully. And here, Barrett is going much further. And I think the reason why is really obvious, right? Justice Jackson's dissent is one of the sharpest, fiercest, most blunt dissents we've ever seen. She is taking on the Supreme Court as an institution in the conservative supermajority. It's one of several dissents she published this term where she accused the supermajority on the right of bias toward the Trump administration, of surrendering the rule of law so that Trump can rule like a king, of essentially degrading our constitutional democracy and turning it into a monarchy that Trump can rule by himself. And she's saying not just that the majority is doing this by accident, that it's stumbling into this, but that it's doing it on purpose because this is how the majority sees the country, that they really believe Trump should rule it with no limits. And, you know, I think after this decision, it's kind of hard to argue with that, right? You know, the majority sees a policy that is so patently unconstitutional, and rather than understand that that's the emergency that courts need to address, it turns around and smacks down the lower courts and says, you went too far. So Jackson's criticism there was entirely appropriate. And for Justice Barrett to act so wounded and respond so personally is really out of bounds, disrespectful, and arrogant.
Yes, you heard that correctly. Justice Barrett essentially says that Justice Jackson is not smart enough to criticize her opinions. It's a low blow, disrespectful, inappropriate, and typical MAGA behavior. So let's take a look at who Justice Barrett is calling stupid. Ketanji Brown Jackson received her undergraduate and legal education at Harvard. Harvard is rated #1 in the world. She was an editor of the Harvard Law Review. She graduated from Harvard College, magna cum laude in 1992. She graduated from Harvard Law School, cum laude in 1996. She clerked for U.S. Supreme Court Justice Stephen Breyer. Barrett, on the other hand, went to Rhodes College in Memphis, Tennessee. Rhodes is ranked 2,414th in the world. She majored in English literature and French. She graduated in 1994, magna cum laude. She graduated from Notre Dame Law School, summa cum laude in 1997. She clerked for Justice Anton Scalia, the justice who thought that Black students should go to, quote, a slower track school where they do well. Ketanji Brown Jackson served as the vice chair of the United States Sentencing Commission for 4 years. She was appointed to the bench in 2013 while Barrett was still teaching at Notre Dame. Justice Jackson served as a district court judge for 7 years and on the Court of Appeals for a year. Barrett was only on the Court of Appeals for less than 3 years before Trump nominated her for the United States Supreme Court. What Barrett is telling us, and all of America, especially MAGA, is that Justice Ketanji Brown Jackson is just another uppity Black woman who doesn't know her place. And that's what we're dealing with in Trump's America. Thanks for tuning in to Pamela Price Unfiltered. And don't forget to like, share, and subscribe to my YouTube channel to watch the weekly show. And please sign up this month as a founding member of my Substack or a paid subscriber. Your support keeps the conversation raw and unfiltered. And you can listen to this podcast wherever you get your podcasts. Thanks for tuning in.